All right, good evening, folks. Let's get this microphone over here. Good evening, folks. Welcome to Monday Night Law here in Kirk's Law Corner. We're going to continue on with Blackstone's, getting into some of them certain auxiliary subordinate rights. And some good stuff in there. I'm going to back up just one section from kind of where we left off last week because it kind of really needs to tie together in one video here. But dang it, sorry about that over there on Telegram. Forgot to unmute myself on Telegram. So good evening to you folks over there on Telegram. Now, if you have a question, make sure that you put your question in the comments section there, and try to keep your questions related to the subject matter of the video here tonight. Diesel D, Zigger Beaver, good to see you. Of course, over here, corruption detector Leslie. Oh man. So a lot of crazy stuff going on out there, right, folks? Border stuff. Good old Supreme Court ruling over there. I haven't kept up on much of anything else. Been focusing on my own stuff, my own case. Just to touch on that a little bit. Sentencing hearing was on Friday. And judge did basically what I thought he was going to do was, implement the 2 days jail that I'd already spent, credit for time served, and did the math to spread it out to give themselves $142.50 for a fine, and the rest of the $300 cash bond went towards court costs. So, on to my appeal. So that's what's next. Brother Rob, good to see you. Oh boy. Brian over here on YouTube asked, did you hear about the federal case out of Illinois, U.S. versus Cherry? I had not. Judge ruled 18 U.S.C. 921 G1 unconstitutional. Finally, felon in possession of firearm is legal. Well, the thing is, again, prima facie, that what the Supreme Court is doing is reestablishing the rule of law and back to the laws of nature. Clear back to New York Supreme Court or New York State Rifle Pistol Association versus Bruin case. This was June of 2022. And this is what brought me to Blackstone's Commentaries on the Law of England, is because they went all the way back and they specifically stated they did not care about any statutes or any case law after the Second Amendment was written. They were wanting to go back to when the founders, what the intent of the founders was at the time that they wrote the Second Amendment. Why would they say that? Okay, we're going back to fundamental law, folks, the common law, the laws of nature. Okay, and that's why it's so important to read the stuff that we're reading from, because again, that goes right back to where I started reading from on these three absolute rights, and then we're going to get into some auxiliary rights, okay, tonight. But the first one, that first absolute right, which is exactly what the Supreme Court cited from, is the laws of nature. That's a fundamental right of self-defense. Now, you'll have to go back a few episodes to catch that very first part, or go read it for yourself again. But there's more to that right of personal security, like the right to choose our own health, It is an absolute right. Government doesn't have any authority over our rights. Well, we have the power to regulate. No, you do not. Clearly. And so, as Brian just posted out here on YouTube, I need to go find that case and see what they cited for there. But more than likely, right back to the laws of nature. It's going to be they're tearing this stuff down. And like what Trump was saying a long time ago, well, somebody ought to sue these people. Now, keep in mind what I kind of already showed and talked about, more specifically over in the Wednesday night workshop, trying to keep this on the private side. But the fact is I'm doing constitutionality challenges. And this is going to affect not only everybody in Idaho, it's going to affect everybody. This Roman civil law, the code, needs to go away. United States Code. Like what's being cited right there. 18 United States Code. That is Roman civil law. Doesn't belong in our republic. Okay, it's in the Declaration of Independence, subjecting us to a jurisdiction foreign to our form of government. Jurisdiction, body of law. That's Roman civil law. That's what they were talking about back in 1776. This Roman civil law. And I've already covered that right out of Blackstone's Commentaries on the Law of England. That, the clear distinction between the Roman civil law, the feudal system, and the common law. And the origin of the common law was from the Saxons, which were the Christian Protestants. Was what? Maxims of law and customs. Now, a comment I was going to make earlier on that particular case there is I found in my Idaho Criminal Practice Act of 1864, it specifically states in there that once you're done with your sentence, whether it's misdemeanor or felony, you get all of your rights back. All of them. There's no such thing as, well, you lose your Second Amendment rights if you're convicted of a felony. No. No. Because why? I'm willing to bet in that case right there that Brian was just citing, they went back to the laws of nature, back to Blackstone's Commentaries on the Law of England. The fundamental right of self-defense. You cannot take away that right. Now, it can be temporarily deprived, like what they said in the other case was while incarcerated. Obviously, you're not going to be able to keep and bear arms while you're incarcerated serving your time. And like I've said before, way back in the day, used to be on the books that once you got out of prison, they gave you a horse and a rifle and $100. Rifle and ammunition. Okay. There's a very, 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 very clear distinction there that, hey, you can't deprive that fundamental right. And a man has a fundamental right to defend himself with arms. Okay? It has been throughout history. I would say guaranteed. It's in the first Charter of Virginia of 1606. It says right to have arms while out on adventure. And nobody's supposed to be depriving that right. So here in America, starting in 1606, with the American common law, not to be confused with the English common law, but one step at a time here. But, yeah. Right, Mark? Traditionally, here on YouTube, everything I see in the code is for those that serve, public servants or corporations, like I found in the Idaho Code there. Public statutes are for corporations. What was it? The actual verbiage was creating and affecting corporations. So they're not even following their own code. But the reality is, again, code is Roman civil law, and it doesn't belong in our republic at all, anywhere. And in 1881, for Idaho, is when they implemented the code here. So this is part of what I'm talking about in my constitutionality challenges here. As I'm going through the history, and I'm finding where, doing the diagnostics here, finding out where we went off the rails here, and where the law got changed from the common law, the laws of nature, the law of nations, over to the Roman civil law. For Idaho, it was 1881. I found the Code of Civil Procedure Act. And that third section is the big red flag. It says that, the rule of the common law, the statutes and derogation thereof, is supposed to be strictly limited or construed like that. Anyway, does not apply here, and the code is the law. Okay? You picking up what I'm laying down, folks? So this is the fundamental alteration, altering the fundamental law. And see, Law of Nations, Book 1, Chapter 3, Section 34, again, the question was asked and answered, does the legislature have the power to alter the fundamental law or the Constitution? The answer is no. How can that which is created alter the laws of its own creation? If we the people laid down the law by declarations, bills of rights, lays down the law, and then we institute government to secure those rights from infringement, from trespass, how is it that they have the right to alter that? So this is going to get quite interesting here very quickly, as I not only am filing the appeal, okay, it's also has to go to Congress pursuant to Article 4, Section 4, to guarantee a Republican form of government. Congress is the one that is supposed to ensure Republican form. See, back to the Declaration of Independence, subjecting us to a jurisdiction foreign to our form of government. That's what Article 4, Section 4, in part, is about. The guarantee part of a Republican form of government is to keep us from turning even one state back into a monarchy. Well, this has happened nationwide. So, hi Jax, good to see you. Hi James, out there on YouTubey. No, I didn't get a legitimate, to answer the question over here on Telegram, no, I did not get a legitimate trial by jury. I had 2 trials, jury trials. See how it's said there? Jury trial versus trial by jury. Right? And that's part of what I've been covering there with Lysander Spooner on the right to trial by jury, which once I get done going through Blackstone's here, we're going to dive more into that. But on Friday nights, now, that's what I've been digging into over there. So make sure you're getting in on the Friday nights lives. And again, that's only on the Telegram, the KLC American Patriots Telegram channel. Okay? So that's it. That's it over there. But that's part of the constitutionality challenge. But the reality of the code, once we take the code down, it's all over, because that's where they put in there that they've subverted the right to trial by jury. Trial by jury comes from the common law, and jury trial comes from the Roman civil law. So this is part of that fundamental alteration of our form of government. They've subjected this jurisdiction, Roman civil law, which subverts, and is, as Bouvet's Law Dictionary 1856 says, it is opposed to the law of nations, laws of nature, and the common law. So 2 different fundamental laws, 2 different jurisdictions. And that, again, that is what is in Blackstone's Commentaries on the Law of England as well, which I've already covered that in, I believe that was in Book 3. Volume 2, Book 3. So, No. Nope. The videos that are in there under the KLC American Patriots stays there and doesn't go anywhere. Okay? Hey, Jim. Good to see you. Out there on YouTube. Yep, yep. Good stuff, right? Yeah, well, there's there's other things going on with the border stuff, folks. And I've been informed by one of my contacts that there are some Polish people now coming in. These people are coming here to train as militia. Now, notice that I'm using the word militia and not military. The militia is composed of the body of the people themselves. That's why the Second Amendment says the right of the people to keep and bear arms shall not be infringed. When it comes after that a well-regulated militia being necessary for the security of a free state. And that the right of the people to keep and bear arms shall not be infringed, because when the people can't defend themselves from their own government, then we're under despotism. And that's precisely what the Supreme Court is undoing now. Right now. It's happening over the last year and a half. Okay, so yeah, there's some bad guys that are coming in. Make no mistake, there's that. But there's good people coming in as well. And remember, this is a worldwide war. So some of these men are coming here to train and then going to go back to their nation state countries and do what needs to get done there as the militia, which the government doesn't have any authority over. Now, I've heard that there's some sort of bill going through there to try and make, paramilitary organization, whatever, unlawful. They don't have that authority. And here's the Supreme Court over here, left and right, declaring stuff unlawful and unconstitutional, specifically regarding the right to keep and bear arms. So, I don't know how Congress is over there trying to write legislation. It's just another Patriot Act, basically. But, no, it's not well organized, it's well regulated. A well-regulated militia being necessary for the security of a free state. The regulated militia is the military. So we're supposed to have an organized militia for the state and federal. And the unorganized portion is the people themselves, which all of the military, has to come from the pool of the people themselves. That's the way our founders set up our republic. Okay, of the people, by the people, for the people. Not for the corporations, but for the people. Okay? So, there's three parts to the militia. This is a question I pose out there all the time. Where is the organized military for the states? Like Texas, they call it on the National Guard. That's national. How does the state call the national? No, the state can't call the national. That's federal organized militia. Where's the state militia? Where's the state military? I'll let you in on a little secret. They call it police. Okay, your state police and then your city police, so-called law enforcement officers. That's them erecting a multitude of new offices, sending hither swarms of officers to harass our people and eating out our substance. No standing armies, no armed bodies of men outside of the militia. I didn't write it. I wasn't alive back in 1776 era when this stuff was written. But I sure know that it was written. I sure know that what it meant at the time. Okay. So we've got a battle ahead of us, to make no mistake. So was also informed Thursday night last week. We got about 5 weeks to get our stuff together. So when it comes to reassembling government de jure, we better figure this stuff out soon. Otherwise, we'll be stuck under martial law until each of the states, until we get to the 38 states. I mean, I'm only one man. I can only do what I can do. But make no mistake here, I will be a part of what's to come and the new law that's coming. Right, James? The people wrote it and Kirk reads it. Damn right I do. Because reading means reading. So without further ado, let's get into some reading, shall we? Because ultimately, reading means reading. Yeah, it goes way too big, damn it. But I know where it needs to be. Oh, come on. Okay, that's close enough. Let's see, and we were supposed to be at, yeah, I'm going to go right up to right here in this paragraph here. Now this says, in the 3 preceding articles, we have taken a short view of the principal absolute rights which appertain to every Englishman. Now, those 3 principal absolute rights, remember, was the right of personal security. That's where the Supreme Court cited from right here. Okay? The right of personal security. Then you have the right of personal liberty, which consists in the power of locomotion. Uh-oh. And then the third one is the right of personal property. So those are the 3 basic ones. And think about this for just a second. Doesn't that correlate to life, liberty, and property? Wait, yeah. Why do you think our founders used that? I know they did say pursuit of happiness, but in essence they were referring to pursuing your property, acquiring and possessing property, right? Because personal liberty already covers that going wherever you want to go and do whatever you want to do. Back to the very first fundamental principle of the laws of nature, really, is do no harm. Okay. So, but in vain would these rights be declared, ascertained, and protected by the dead letter of the laws if the Constitution had provided no other method to secure their actual enjoyment. It has therefore established certain other auxiliary subordinate rights of the subject, which serve principally as outworks or barriers to protect and maintain inviolate the 3 great and primary rights of personal security, personal liberty, and private property. Okay? These are, so what is it? It's the Constitution, the powers and privileges of Parliament, of which I shall treat at large in the ensuing chapter. Okay? The limitation of the king's prerogative by bounds so certain and notorious that it is impossible he should either mistake or legally exceed them without the consent of the people. Of this also I shall treat in its proper place. The former of these keeps the legislative power in due health and vigor, so as to make it improbable that laws should be enacted destructive of general liberty. The latter is a guard upon the executive power by restraining it from acting either beyond or in contradiction to the laws that are framed and established by the other. Not statutes. Constitution is ordained and established. Like the Magna Carta. And then a third subordinate right of arrangement is that of applying to the courts of justice for redress of injuries. Now, we went around this last week. So this is where we kind of have to take into consideration of the government de facto we have now versus government de jure, where the people have the power and we have our actual courts of justice, which I was led to believe, technically speaking, is the legislature, but in retrospect here, it's really the common law courts, suits at common law. And finding that stuff in there where we actually we're supposed to be prosecuting the public servants. In the private over here, suits at common law. We drag them over here and say, no. That's the court of justice. Yes, sir. So this is the part of our Republican form of government that's missing. Everything else looks very close, similar, kind of, except for with, like the committees. The committees are supposed to be done by the people, not by the public servants. I wonder how many people knew that. The other part is the common law grand juries. The grand jury is supposed to be assembled every time. For every time there's an issue. And if somebody has a standing for a cause of action, supposed to be drawn by lot. 25 men. Each time. Not supposed to have a sitting or a standing grand jury that's, that's it. That's the grand jury. No. But see, this is part of what we're supposed to be doing. We got to bring the people together. We have to declare this stuff. And you want to talk about correcting your status. This is it. This corrects your status to one of the people. Having all political power. So everybody out there that's talking about supposedly correcting their status to an American state national, you're wrong. You've been duped. You've been lied to. You've been tricked. Anybody's done any of that supposed David Straight, Anna Von Reitz, or Bobby Lawrence correct your status stuff, that's wrong. They're using United States code. And they're telling everybody that you're pulling yourself out of there, this citizen of or United States citizen and all that. I am man, creation of God. Can you rebut that? The answer is no. So just exactly what would I correct my status to? Well, the status they're saying is this American state national, which doesn't actually exist. The word national does, yes. But national as a noun, okay, that proper noun, national, that status, supposedly, it says a citizen of the United States. In the United States Code. You won't find that in the Law of Nations. Because it was created in 1878. And the only source of law is the United States Code. But I thought correcting your status was to pull you out of the United States corporation. But then you're citing the bylaws of a corporation, the code. Huh. Come on, people. Use just a little bit of logic and reason here. Again, the three fundamental statuses that we have are inhabitants, the people, and citizens. Law of Nations, Book 1, Chapter 19, subsection 212, citizens. Those are the members of the legislative, executive, judicial branch who shall be bound. That's Article 6, Clause 3. Those are the citizens. Then you have the inhabitants, which is Section 213. And then it does say that there's a different kind of citizen in there. That's the people. You know, the ones that are the people that declare their status, that they're gonna settle here, become a resident. I know some people have a problem with that word, but it's right there in Law of Nations, or residence. Okay, that you intend to settle, and that's the thing is essentially you're supposed to own land. That's what gives you standing as one of the people. I know that there's a lot of discussion on property taxes, but in my mind and what I have found originally, that's the way taxes got paid, and that's how you become one of the people too, is you're paying the bills. If you're paying taxes, I mean, think about this. How else does the governor get paid? How does your state representatives get paid, either representatives or senators? How does the sheriff get paid? Where's their just compensation? How about the judges? The good ones, right? The real judges, right? Justice of the peace and that kind of stuff. How are they supposed to get paid? And I've talked about this before, and I know it's some of the things that, who are the people? What makes a man or woman one of the people, and essentially man, but there's the answer to that question. People like business owners, landowners, the ones that pay the taxes, the one that pays the bills, they're the boss. Otherwise, you're just an inhabitant. You don't have political rights. It doesn't matter either. It's okay to be an inhabitant because none of this stuff's supposed to apply anyways, either to the inhabitants or to the people. Okay. Now, the third subordinate right of every Englishman is that applying to the courts of justice for the redress of injuries, since the law is in England the supreme arbiter of every man's life, liberty, and property, courts of justice must at all times be open to the subject, and the law be duly administered therein. The emphatical words of the Magna Carta, spoken in the person of the king, whom in judgment of law, says Sir Edward Coke, is ever present, and repeating them in all his courts, are those, here we go, a bunch of Latin stuff. And therefore every subject continues the same learned author, for injury done to him in by any other subject, be he ecclesiastical or temporal, without any exception, may take his remedy by the course of the law, and have justice and right for the injury done to him freely without sale, fully without denial, and speedily without delay. You know, we're supposed to have these rights, folks. Gotta love spammers. Gone. Bye-bye. Yes, Scott, but the state level has to be assembled first. Then you can do the counties. Can't have a county within the territorial limits of a state or territory without the state level done first. And this, what I just read there, this is chapter 40 of the original Magna Carta, 1215. To no man will we sell, to no man will we deny nor delay right or justice. That's what they're citing there is from the Magna Carta. So it were endless to enumerate all the affirmative acts of Parliament wherein justice is directed to be done according to the law of the land. Huh. No, a man's word is not his bond. An oath. There's no firmer bond among men than an oath. So, even the Bible tells us not to swear unless he be judged. That's why we require everyone to be under oath. Affidavits, notaries, swear people in under oath, under jurat. That's the jurat. Okay? It's a maxim of law. There's no firmer bond among men than an oath. Let's see. Let's see here just a minute. Yeah. Where is mine? Hopefully this doesn't have. Yeah. Let's see. Here. Now notice this, again, it's supposed to be according to the law of the land. Now, like when we look at our supreme law of the land, that federal constitution, supreme law of the land, law of the land really means common law of the land. I wonder how many people know that one. And then your state constitutions are law of the land. So when it's talking about this all supposed to be done according to the law of the land, that exempts any statutes. Because statutes are not law of the land. They're statutes. But we don't even have any legitimate statutes anymore. It's all code. Plain and simple. And what that law is, every subject knows or may know if he pleases. So, how many of you want to know the law? Just about everybody that's here right now. Or you wouldn't be here. Thanks for being here. Thanks for being part of, learning. Because this is, knowledge is power. We don't have this knowledge, we ain't got no power. For it depends not upon the arbitrary will of any judge, but is permanent, fixed, and unchangeable, unless by authority of Parliament. Now, in part, this is the thing, the change between the English common law and the American common law is we didn't give the legislature the authority to alter the fundamental law. Due process of law. Uh-oh. That's right. We didn't give them that power. They didn't have subject matter jurisdiction. I shall, however, just mention a few negative statutes whereby abuses, perversions, or delays of justice, especially by the prerogative, are restrained, the king. It is ordained by Magna Carta that no free man shall be outlawed, that is, put out of the protection and benefit of the laws, but according to the law of the land. Now, Lysander Spooner now, in here, he's exposing this. Originally, he's breaking down, because see, this was originally written in Latin. And he's exposing the fraud, even by Sir Edward Cook. Now, he's talking about here, the most common translation of these words at the present day is as follows: no free man shall be arrested or imprisoned or deprived of his freehold or his liberties or free customs or outlawed or exiled or in any manner destroyed, nor will we, the king, pass upon him nor condemn him, unless by the judgment of his peers or the law of the land. Okay? So even here, Blackstone isn't citing it correctly. But that happens. And he may be paraphrasing just in that particular part. This here, Edward the third, whatever the other one is enacted that it is enacted that no commands or letters shall be sent under the Great Seal or Little Seal, the signet or privy seal, in disturbance of the law, or to disturb or delay common right, common law, common right. And though such commandments should come, the judges shall not cease to do right, which is also made part of their oath by statute. Now, we made the oath requirement per the Constitution, the supreme law of the land. That's Article 6, Clause 3. Every single member from the legislative, executive, and judicial, both state and federal, shall, that is mandatory, be bound by oath or affirmation to support this Constitution. Then this one here, the William and Mary, that's the English Bill of Rights of 1688-1689. It is declared that the pretended power of suspending or dispensing with laws or the execution of laws by regal authority without consent of Parliament is illegal. Not only the substantial part or judicial decisions of the law, but also the formal part or method of proceeding cannot be altered but by Parliament. Now, this is where we get into the one case there. It's on the tip of my tongue. That it was manifest it was not left to the legislative branch to make any process due process of law. Why? Because due process of law comes from the common law of the land. And I've showed this before. American Jurisprudence, Volume 16, Constitutional Law, Section 100, 2017 update. So this isn't something old and outdated. The Bills of Rights and those merely declaratory of the common law. Those constitutional provisions are mandatory. That's right. So, now we understand the Bills of Rights, especially like the Bill of Rights for America here, 1791 there. Those are all just merely declaratory of the common law. All of those rights that are enumerated 1 through 8, they already pre-existed government. Hale versus Hinkle, our rights are long antecedent to the formation of the state. Long before. As we're reading, clear back in history, clear back to Blackstone citing it. Okay? For which reason it is declared in the statute 16, blah, 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 upon the dissolution of the court of Star Chambers. Yeah. Good old Star Chambers. That's them juvenile hearings that they do now. Those are Star Chambers. Oh, it's closed off to the public. Nobody can do this. Nobody can be in here. And these are all sealed. No. It's all supposed to be a matter of public record. Supposed to be open to the public. All courts of justice are to be open to the public. But again, these are all Roman civil law courts. These are back to the Star Chambers. And what does it say? That neither His Majesty nor His Privy Council have any jurisdiction, power, or authority by English bill, petition, articles, libel, which were the course of proceedings in the Star Chamber, barred from what? The civil law. That's the Roman civil law. Again, wasn't around when this was written. But that's why reading means reading, because that's what it says by Blackstone. He wrote this. Okay? These are words written by Blackstone himself. Not by Kirk Pendergrass. Not my opinion. These are facts of law. We're reading it right on the screen. Or by any other arbitrary way whatsoever to examine or draw into question, determine, or dispose of the lands or goods of any subjects of this kingdom, but that the same ought to be tried and determined in the ordinary courts of justice and by course of law, due process of law. I want to remind people that anytime we see course of law is due process of law from the law of the land. Because again, law of the land literally means due process of law. Okay? Now we're getting into chapter 143 here, section 4. If there should happen any uncommon injury or infringement of the rights before mentioned, which the ordinary course of law, due process of law, is too defective to reach, there still remains a fourth subordinate right, appertaining to every individual, namely the right of petitioning the king or other house of parliament, legislature, for the redress of grievances. That's where we talked about this before. In Russia, we were told that the Caesar Peter established a law that no subject might petition the throne till he had first petitioned 2 different ministers of the state. In case he obtained justice from neither, he might then present a third petition to the prince. But upon pain of death, if found to be in the wrong, the consequence of which was that no one dared to offer such third petition. So people were getting, executed for filing a third petition. So that was kind of a scare tactic, right? Well, star chambers are like the your CPS courts, your juvenile courts. That's what they're doing. Those are the back to the Star Chambers. That's the same crap they were doing before. Okay, especially supposed domestic violence protection order hearings. No, nobody can be in there. Nobody can be a part of that. What? Where's the trial by jury? Oh, you don't get one of those in here. What's a Star Chamber? And grievances seldom falling under the notice of the sovereign, he had little opportunity to redress them. The restrictions for some there are, which are laid upon petitioning in England, are of a nature extremely different. And while they promote the spirit of peace, they are no check upon that of liberty. Care only must be taken, lest under the pretense of petitioning, the subject be guilty of any riot or tumult, has happened in the opening of the memorial parliament in 1640. And to prevent this, it is provided by the statute, blah, 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 that no petition to the king or either house of parliament for any alteration in church or state shall be signed by above 20 persons, unless the matter thereof be approved by 3 justices of the peace, or the major part of the grand jury in the country, and in London by the Lord Mayor, Aldermen, and Common Council, nor shall any petition be presented by more than 10 persons at a time. Now, there you are, Tiger. Good to see you. And yep, this is the right of petition for the redress of grievances. So, like it says here, if you can't get it through supposedly the judicial branch, which is technically where this is supposed to be done, is in our common law courts. If we can't get remedy there, then we can resort to this petition. Because now we're talking about needing oversight. And there is no limitation. Okay? That's in Lex Parliamentary Americana. But under these regulations, it is declared by the statute, that's also the English Bill of Rights there, that the subject hath the right to petition, and that all commitments and prosecutions for such petitioning are illegal. So there you have it. In 1688, 1689, English Bill of Rights, it made it very clear that you can't retaliate against the people when they petition. Section 5. The fifth and last auxiliary right to the subject that I shall at present mention is that of having arms for their defense. This is in addition to the fundamental right. See, these are auxiliary too. This is good, folks. The fifth and last auxiliary right of the subject that I shall at present mention is that of having arms for their defense, suitable to their condition and degree, and such as are allowed by law. Well, remember, this is still English common law, which is also declared by the same statute in the English Bill of Rights, and is indeed a public allowance under due restrictions of the natural right of resistance and self-preservation when the sanctions of society and laws are found insufficient to restrain the violence or of oppression. That's talking about government oppression. That's what the right to keep and bear arms is about. It's defending ourselves from a tyrannical government, from oppression, from despotism. Imagine that. Right there in Blackstone's Commentaries on England. It even adds the very verbiage is that of having arms for their defense. And then I know it says, well, allowed by law. Well, the Second Amendment is very clear. It says, shall not be infringed. So any infringement on this fundamental, absolute right or auxiliary to the right of personal security, where in the Second Amendment does it say, and the legislature shall have the authority to regulate this right, or to make appropriate legislation? No, it says shall not be infringed. That's mandatory language. Plain and simple. In these several articles consist the rights, or, as they are frequently termed, the liberties of Englishmen. Liberties more generally talked of than thoroughly understood, and yet highly necessary to be perfectly known and considered by every man of rank and property, lest his ignorance of the points whereon they are founded should hurry him into faction and licentiousness, on the one hand, or a pusillanimous indifference and criminal submission on the other. Okay. Basically, what that says there is we can't claim ignorance. And if you're ignorant of your rights and these specific points that I've covered over the last 7 weeks now, what is that going to lead you to? Well, you got to have a license for that. Like a driver's license, like a concealed carry license, like New York legislation that you had to seek permission to even have a gun, to carry it. That's what the New York State Rifle Pistol Association versus Bruin case was about, was the legislation, right? In New York, and was like 7 other states at the time. And like the Supreme Court said, all of them, strikes it all down. Any legislation that says you have to seek permission to carry arms, either open or concealed, is unlawful and unconstitutional. That's what that case struck down, folks. Period. It's done. There can be no legislation out there that says we have to seek permission, either open or concealed. See, the right to keep it where we want to keep it. That's right. Whether it's concealed or open. Imagine that. That's what that keep means. And bear means to take up arms to restrain or resist violence of oppression. That's what the bear arms means. It means to literally point it at them. People think bear, in essence, I think that people think that bear arms means to open carry. That's not what bear arms means. Bear arms means to take up arms, to point them at the oppressors. Now, again, I will reiterate, I do not advocate for violence. This is about education. But facts are facts, facts of law. And these are absolute rights. We have the absolute right to defend ourselves, the right of self-defense. In addition to that, as an auxiliary right, no, it's not an auxiliary, it's an absolute right. It's in the Second Amendment. We laid that down. We declared it. Made it very clear. And it shall not be infringed. Period. I mean, what part of infringed shall not be infringed do you not understand? It means no jurisdiction. None. But again, if we don't know this, which is why I'm here covering it, they get away with it. And I'm glad the one gentleman there earlier that shared that Illinois case from all the way to the Supreme Court, and they struck down that the felons can't have arms. Yep. Well, now we know. Everyone that is here right now should know this. Right? This is common sense law stuff. Right? But you can definitely cite, the Supreme Court citing Blackstone, why not? So, if you're looking for this, Again, this is Blackstone's Commentaries on the Law of England. This is Volume 1, Book 1, Chapter 1, subsection 144. And that would be the fifth section, which started at, what was that, 141. So let's quit being ignorant of our rights, folks. Let's learn what our rights are, so we know how to tell them to piss off. You know, this is something I've said before is, okay, if you're going to write paperwork, you got to do the paperwork, right, for your court case or whatever. What are you going to put in your paperwork? What are you going to cite as law? If you don't even know what your rights are, how in the hell are you going to put it on paper and submit it to somebody? Completely illogical, isn't it? This is why I keep saying we got to learn what our rights are first, where they come from, and then how to effectively claim, exercise, and defend them, following due process of law of the land. What's the process that is due? Let's see. And we have seen that these rights consist primarily in the free enjoyment of personal security, personal liberty, and the private property. So long as these remain inviolate, the subject is perfectly free. For every species of compulsive tyranny and oppression must act in opposition to one or other of these rights, having no other object upon which it can possibly be employed. Wow. That's that perfectly free as opposed to slaves. Yep. Again, for every species of compulsive tyranny and oppression must act in opposition to one or other of these rights, having no other object upon which it can possibly be employed, meaning it's void for any effect. If it comes in conflict with in the free enjoyment of personal security, personal liberty, and private property, we have the right to resist that, and that's why our founders made it very clear that we have the right to keep and bear arms, and that right shall not be infringed. They were tired of the tyranny and oppression and wanted to ensure that we had a well-armed people. Okay? Whew. I don't know about that one, Mark. Out here on YouTube, didn't those top law schools all agree that the people have no less than 1,400 rights? I know that I read somewhere there was 156 articles that was originally submitted for the Bill of Rights, the original Bill of Rights, and they whittled it down to 8. I think they should have done all 156. But, like Carl Miller said, if you can think that you think about a right and you can articulate that right, you have that right. Right? To preserve these from violation, it is necessary that the Constitution of Parliament be supported in its full vigor, and limits, certainly known, be set to the royal prerogative, which is kind of like what the Magna Carta did. But that's why we have language like shall not be infringed. I don't know how much clearer that can be. And lastly, to vindicate these rights when actually violated or attacked, the subjects of England are entitled, in the first place, to the regular administration and free course of justice in the courts of law. Next, to the right of petitioning to the King and Parliament for redress of grievances. And lastly, to the right of having and using arms for self-preservation and defense. Okay, now, this is exactly what I'm talking about. The first article of the Bill of Rights, First Amendment, is the right to petition the government for the redress of grievances. Now, that can be done through, one, courts of justice. If we can't get justice through the court of justice, then we would apply to the Supreme Court or to the legislature. And that's succinctly stated in the Declaration for the Cause and Necessity of Taking Up Arms, July 6, 1775, is that they had petitioned, they had remonstrated, and only been met with repeated injuries, that they have been reduced to an absolute despotism. See, we can't claim that we're under absolute despotism until after we follow due process of law. Does that make sense, folks? So the first article, or First Amendment, comes first, then the Second Amendment. Now, the way the law reads, and there's case law on that, John Bad Elk versus United States, went all the way to the Supreme Court. Nope. That man shot and killed them two deputies because they didn't have a warrant. They tried to put their hands on him, and he drew on them, shot them both dead. And they ruled clear back then that, oh yeah, that's a fundamental right of self-defense. Those men didn't have a warrant. Plain and simple. So there is case law out there that does say that. John Bad Elk versus United States is one of them. So there are certain instances, it's all up to you, it's your choice to defend, right? When actually violated or attacked. And all these rights and liberties, it is our birthright to enjoy entire, unless where the laws of our country have laid them under necessary restraints. Restraints in themselves so gentle and moderate, as will appear upon farther inquiry, that no man of sense or probability would wish to see them slackened. Well, again, shall not be infringed. Our founders knew about the trickery, and they made it very clear. Shall not be infringed. They declared it that way. On purpose. For good cause. Because all throughout history of fighting over this right to keep and bear arms, they'd had enough and said, well, we're going to make damn sure that it's not infringed ever again. Which is what's going on with the Supreme Court of the United States of America right now. They went back to the original intent of the Second Amendment. Shall not be infringed. They're striking down everything, left and right. Back to what Trump said. Somebody ought to sue these people. Well, here I come. For all of us have it in our choice to do everything that a good man would desire to do, and are restrained from nothing but what would be pernicious either to ourselves or to our fellow citizens. So if you cause harm to your fellow man, now they're standing for a right to a cause of action. Otherwise, what? It's our choice to do anything and everything we want to do. Whatever we desire. Freedom of choice. Liberty of conscience. so that this review of our situation may fully justify the observation of a learned French author, who indeed generally both thought and wrote in the spirit of genuine freedom, and who hath not scrupled to profess, even in the very bosom of his native country, that the English is the only nation in the world where political or civil liberty, see, that's that Roman civil law again, no, natural and political liberty, is the direct end of its constitution. Recommending, therefore, to the students in our laws and farther and more accurate search into this extensive important title, I shall close my remarks upon it with the expiring wish of the famous Father Paul to his country. Esto perpetua. Not sure what that actually means, but you Latin folks out there, maybe you can translate that one real quick for us. But I knew it. Okay, I knew it. Montesquieu, Spirit of Laws. Imagine that. That's these two books I got right here. Sitting right here on my desk. Isn't that crazy? Getting down into that root of the stuff. And Oscar, he picked him up a newer version of what we've kind of so far compared. Notes so far so good. But as we go through this, we'll see. But his was like a 19-something version, and mine's an 1878, word for word. So that's good. But that's what Blackstone's referring to right here. That's that spirit of genuine freedom. That's the spirit of law. Okay? All right. Scott Lauterball, you out there on X? Thanks for sharing, brother. Diesel D's out there on X. Thank you for sharing. I know X isn't a big thing out there, but I've added it. So yeah. I don't know what else. Okay, so that's essentially the end of that. Which it's going to be chapter 1, basically, right? Yeah. Okay. That whole chapter 1 there was basically just all about absolute rights and auxiliary rights. And that goes all the way to 145. Yeah, 145. I bet this next section will be 146. Yep, 146. Oh, just for shoots and giggles here. So this is of the Parliament, chapter 2. Still volume 1, book 1, chapter 2, section 146. We're next to treat the rights and duties of persons, not man, as they are members of society and stand in various relations to each other. Now, this is where we get into governor, lieutenant governor, those members of the legislative branch, executive branch, and judicial, that's members. Okay? Those people are in the public. Oh, imagine that. As these are members of a society and stand in various relations to each other. These relations are either public or private, and we will first consider those that are public. The most universal public relation by which men are connected together is that of government, namely as governors and governed. Huh, would that be like the military? Because the governor's commander-in-chief? Or like gubernatorial veto over the legislature? Or to call the legislature in a special session? Things like that? Huh, yeah, those persons. Or in other words, as magistrates and people. Well, again, at the time this was written, this was actually before Emer D. Vattel's, well, it might have been right around the same time-ish that Emer D. Vattel was writing the Law of Nations. No, it wasn't, because Blackstone's original writing was long before Emer D. Vattel's Law of Nations. So, again, want to remind people back to the beginning of this video that I discussed those three different statuses: inhabitants, people, and citizens, coming from the Law of Nations, written by Emer D. Vattel. So, again, we kind of have to decipher some of this stuff because this is still part of English common law stuff and before our republic was ever created. Just so we're clear on that timeline here. Let's see. Of magistrates, some are also supreme, in whom the sovereign power of the state resides. Others are subordinate, deriving all their authority from the supreme magistrate, accountable to him for their conduct and acting in the inferior secondary sphere. See, right there, that should be a dead giveaway. No. The people are the sovereign in our republic. The citizens are the servants, public servants. They're on the clock. They get paid. So that's a little bit of a difference between the monarchy and our Confederate Republic, where all political power is inherent in the people themselves. So I keep hammering that home. That's the status we want. One of the people. We want to be of the people. Because the people are the ones that have all the power. And that's who we need to reassemble. We got to come together, folks. Now, in the Virginia Declaration of Rights, June 12, 1776, it says Virginia Declaration of Rights there that magistrates are what? They are our trustees and servants, and at all times amenable to the people. Which means the people are the sovereign and the magistrates are the servants. See how our founders, through the 1600s all the way into 1776, changed that? It's a completely different form of government. It's not a monarchy. It's a republic. A Confederate Republic. A Union. League of Friendship. Confederacy. You know that we the people, in order to form a more perfect union, that's that Confederacy. Confederate Republic. Covered that last Thursday right here from Montesquieu's Spirit of Law about Confederate Republic. Let's see, inferior secondary sphere. In all tyrannical governments, the supreme magistracy, or the right both of making and enforcing the laws, is vested in one and in the same man, or one and the same body of men. And wherever these two powers are united together, there can be no public liberty. No, but we need to learn that person can be governor, lieutenant governor. Those are persons, personalities, personifiants, characters. Like a movie, they play a role. They have to act out the role. And see, this goes right back into the word government. Mind control. Constitution is the instrument of government. It controls the minds of the men who are elected into those positions, into those emoluments of that. What are the emoluments of the office of governor? What is the mind of the governor? That person. Well, we the people write the Constitution, and we delegate certain powers. That's mind control. We control the mind of the man by Constitution. Because again, Constitution is conscience. See, government is a figment of our imagination. We take those figments of our imagination, we put them down in there, and we call that a constitution. It's our conscience. And it's the conscience for that person called governor. So learn the full meaning of this is not just necessarily person meaning corporations, but it's look at all of the persons that are created in the Constitution itself. The entire legislative branch, the entire executive branch, the entire judicial branch. That's what he's talking about right here. That's what Blackstone is referring to, these persons. The magistrates, the governors. Those are the persons. Okay? Let's see. The magistrate may enact tyrannical laws and execute them in a tyrannical manner. See, now this is where we get back into where the bar will argue that case law is common law. Sure, under the monarchy, not in our republic, the judicial branch, separation of powers. Judicial branch doesn't have the power to make law. Uh-oh. See, again, we have to comprehend the change, the fundamental differences between the monarchy and our Confederate Republic. And that's the other part of this is, this is a one of kind of a government. It has three distinct branches of government. And the first one is the legislative branch. But before that, before the legislative branch gets created, we got to have the common law side of our republic assembled, where the people have all the power. That's the instrument of government that creates first the legislative branch, then the executive, then the judicial. A lot of people seem to get them out of order. But read your constitutions. Article 1 will be your, state constitution, usually Article 1 will be your Declaration of Rights, Bills of Rights. But the first branch of government that's enumerated in that Constitution will be the legislative branch. Then it'll go to the executive, then it goes to the judicial. The federal Constitution is Article 1, legislative branch. Article 2, executive branch. Article 3, judicial. 1, 2, 3. Okay? So all the persons that are created within the Constitution, there's personal jurisdiction over what we, the people, create. Oh, that's right, that we have personal jurisdiction over them. The government doesn't have personal jurisdiction over man and the people. Because the people are the sovereign. The sovereign is the ones that has the power to create. It's like God is the sovereign. God created mankind, right? God created the heavens and the earth, and he created man and all the animals and all that stuff, right? Okay. God is the sovereign. He created. And then we are the sovereign over what we create, which is supposed to be the instrument of government. And also our property, right? Our sons and daughters. We create that. Even though they're technically speaking creations of God, we're all creations of God, fundamentally and principally. The magistrate may enact tyrannical laws and suppose quality dispense of justice with the power which he, as legislator, thinks proper to give himself. Yeah, you wonder why we got away from that kind of form of government, huh? One man having that kind of power? No. But where the legislative and executive authority are in distinct hands, the former will take care not to entrust the latter with so large a power as may tend to the subversion of its own independence, and therewith of the liberty of the subject. So we're starting to get there. With us, therefore, in England, the supreme power is divided into two branches. The one legislative, to which the Parliament, consisting of King, Lords, and Commons. The other executive, consisting of the King alone. It will be the business of this chapter to consider the British Parliament, in which the legislative power and, of course, the supreme and absolute authority of the state is vested by our Constitution. Now, there's a very perfect example of what the difference is. Of the monarchy only has two branches of government. It's got Parliament and the executive. And remember, the king was the judge. Although it says here that Parliament was consisting of the King, Lords, and Commons. But then under the executive consisting of the king alone. So the king is in both branches. You know, it took quite some time to pull the power away from the king and put it into just Parliament. I mean, where the king still retained some power, but the Magna Carta of 1215 really put the kibosh on the king's powers, stripped him of a lot of his powers, and restrained him from taking certain actions. Okay, so the original and first institution of Parliament is one of those matters which lies so far hidden in the dark ages of antiquity that the tracing of it out is a thing equally difficult and uncertain. The word Parliament itself, Parliament and colloquium, as some of our historians translate it, is comparatively of modern date, derived from the French and signifying an assembly that met and conferred together. Was first applied to the general assemblies of the states under Louis VII in France about the middle of the 12th century. Would that be like around 1166 with the Aziz of Clarendon? Let's see what footnote 8A has to say down here. Oh, that says 1272. Okay, then. Where did I leave off? Where's the A at? Oh, right here. But it is certain that long before the introduction of the Norman language into England, all matters of importance were debated and settled in the great councils of the realm, a practice which seems to have been universal among the northern nations, particularly in the Germans, and carried by them into all countries of Europe, which they overran at the dissolution of the Roman Empire, relics of which constitution, under various modifications and changes, are still to be met with in the diets of Poland, Germany, and Sweden, and the Assembly of the Estates in France. For what is there now called the Parliament is only the Supreme Court of Justice. Now see, here we go. Here's one of them instances where it says Court of Justice being regarded as the legislative branch, Parliament, consisting of the peers, certain dignified ecclesiastics and judges, which neither is in practice nor is supposed to be in theory a general council of the realm. Not supposed to be, but I found in my Bills, Quills, and Stills, the Bill of Rights book here that I got from the Supreme Court's gift shop there. It talks about some of the original, what we would call juries in Parliament there were like 600 to 700 or 600 to 800 people. Imagine that. With us in England, this general council hath been held immemorially under the several names of Mitchell's Synoth, or Great Council. Yeah, okay. Great Meeting, and more frequently, or the Meeting of Wise Men, was also styled in Latin, blah, 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 blah. More Latin stuff there. And sometimes, we have instances of its meetings to order the affairs of the kingdom, to make new laws, and to mend the old, or as express it, so early as the reign of Ina, king of the West Saxons, Offa, king of the Americans. Wonder where we got Americans from. Huh. And that's where American common law comes from. In the several realms of the Heptarchy. That's a good one. And after their union, the mirror informs us that King Alfred ordained for a perpetual usage that these councils should meet twice in the year, or oftener, if need be, to treat of the government of God's people. How they should keep themselves from sin, should live in quiet, and should receive right. Our succeeding Saxon and Danish monarchs held frequent councils of this sort, as appears from their respective codes of laws, the titles whereof usually speak them to be enacted either by the king with the advice of his written Gemote or wise men, as blah 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 blah, or to be enacted by those sages with the advice of the king, as all of this more Latin stuff, or lastly to be enacted by them both together, as more Latin stuff. So, as we can see, folks, there's a little bit of history here. Notice just right down here, notice in 1215. Let's see, hence it is disputed appears that parliaments or general councils are coeval with the kingdom itself. How those parliaments were constituted and composed is another question, which has been matter of great dispute among our learned antiquaries, and particularly whether the commons were summoned at all, or if summoned, at what period they began to form a distinct assembly. But it is not my intention here to enter into controversies of this sort. I hold it sufficient that it is generally agreed that in the main the constitution of Parliament, as it now stands, was marked out so long ago as the 17th year of King John A.D. 1215 in the Great Charter, Magna Carta, granted by that prince. So, at that particular point, and he's like he's writing here, right? He's talking about long ago. Wherein he promises to summon all archbishops, bishops, abbots, earls, and greater barons personally, and all other tenants in chief under the crown, by the sheriff and bailiffs, to meet at a certain place with 40 days' notice to assess aids and scutages when necessary. And this constitution has subsisted in fact, at least from the year 1266, there being still extant writs of that date to summon knights, citizens, and burgesses to Parliament. I proceed therefore to inquire wherein consists this constitution of Parliament as it now stands and has stood for the space of at least 500 years. And in the prosecution of this inquiry, I shall consider first the manner and time of its assembling. So, I think we'll cut it off right there. But yeah, folks, I'm pretty sure quite a few people were very enlightened tonight. I was kind of eager to share that part about the right to keep and bear arms there at, I even have it marked here, 144, right? So, yeah, that's some good stuff. Great for citing, right? Citing law. Let me see here. What do I got? Where did... What happened to the Rumble? This is very weird. I know that I had it here somewhere. Not that one. Okay, well, I know that I had one up, unless it closed it by itself. All right, so here's my website, kirkslawcorner.com. Thank you, Fix It Fast out there, putting all that good stuff out there on YouTube. Now, for everybody else, if you want links to my other social medias, Facebook, Telegram, I want to reiterate, Telegram is where I do a lot of sharing, folks. So if you're over there on YouTube or somewhere else, get on this Telegram channel, okay? And then there's Patreon, there's YouTube, there's Rumble, and there's my X. Okay? So go ahead and subscribe to all of those if you so choose. But if anybody would like to support me over here, send it to me, Kirk Pendergrass, here at the office with the new address, which really didn't change much, just the Sweet G, as in golf, from Charlie to golf. Any of those regular, you got postal money orders, regular money orders, cash wrapped aluminum foil, gold, silver coinage, anything like that, you can send over to the office, please. I know, right? Yeah, any of the law books or anything like that. I don't really have a wish list going right now, but in the library tab here, now see, this is where a lot of these books and stuff that are already here. I kind of got them in a chronological order of things. Now I'm going to have to find the time to get on here to put, need to put Blackstone's Commentaries on the Law of England in here, and Lysander Spooner's essay on the trial by jury. That really needs to be up here in the first ones. But I'll tell you right now, the treatise on arrest and false imprisonment ties right into Blackstone's Commentaries on the Law of England. Okay? But this, here's the Law of Nations right here. Here's the treatise on arrest and false imprisonment. Got that Lex Parliamentary Americana right here. I wonder, that kind of got messed up here. But, yeah. That's the first one, is Lex Parliamentaria Americana. Then this is the Mason's Manual of Legislative Procedure 2010 edition, which references Lex Parliamentaria Americana. And then you got Jefferson's Manual, Parliamentary Practice. And then you got an older version, 1953 version of Mason's Manual, which I started with that one. Didn't realize that there were newer versions. And then I got the 2010 and the 2020 edition. And boy, did they bastardize the 2020 edition. But then you get into the Commentaries on the Constitution by Joseph Story. And here's your the Bouvet's Law Dictionary 1856, Black's Law Dictionary 4th edition. Here's a collection of maxims of law. And then I threw that Virginia Declaration of Rights and some other stuff down in here. Okay. So there's lots of books to download and read from right here, but obviously, right here, Mark, it's where it says Law and Practice of the Legislative Assemblies of the United States of America. That's Lex Parliamentaria Americana, right? This is the common law on parliamentary practice. And again, this is at kirkslawcorner.com under the library tab, right there. Okay. And then over on the Thursday nights there, National Assembly. Okay. Now, if you want to figure out your state stuff, there is some here for the state websites that already have their websites up. You can also go into, you'll have to sign in, I think. But you go into the forums and blogs, and you can find your individual state. There's a blog in there for each state. So you can go in there and introduce yourself in there. I don't know how many people are really paying attention to that much, but other than that, Content Manager 1, the number 1, not O-N-E, but the actual number 1, at yahoo.com. If you want to contact Destry or them over there, they'll get you directed to the right people in your territory, in your state. Okay? So I know I've seen a lot of people out there. But right here where it says conference call info, this is where you get to the conference call information. Now, again, I highly recommend downloading and installing Free Conference Call. It's a free app, okay? But for those that don't have smartphones or a desktop, a laptop, tablet, whatever, or not wanting a smartphone, you can actually dial in, okay? And then if you're one of those that dials in on your phone, it's *6 to mute yourself. So make sure you're muted. This seems to be a common issue. It's called decorum, folks. You keep yourself muted unless you're speaking, intend to speak. It's disruptive to the meeting. So I want to remind people to mute themselves and keep themselves muted at all times, unless you're going to speak. Okay? Here's a tutorial for smartphones. One for, it'll probably be on both. It'll be Android and, that other one over there. And then there's another tutorial video for desktop computers. Okay? For the apps from YouTube. And then this right here. Here's the link. You click on that after you have Free Conference Call installed. Once you get it installed and set up, all you do is come here and click on this, and then once you do that once, it'll store it in your app. So you don't have to come back here every single time. But now there's some people out there that are on my Telegram channel there that know who to contact over there. So, don't be afraid to put out there, hey, I'm from Indiana, I need to get in contact. Well, I don't have all of that information offhand, so but somebody else might out there. I know Oscar directed one out there, and possibly a second one out there was directed too. So, Freedom Fighter, I told you this last week. Yes, if you're in Canada, doesn't matter. Get on the call. Yes. You asked that question last week. Answered it. Yeah. So, yep, that's where you got to go here to get all that information regarding the free conference call app and the link to the call for the National Assembly call Thursday nights. Okay, 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m., 9 p.m. Eastern. Okay, the first part is the General Assembly business. If there's a coordinator, moderator, somebody in charge in your state, let them answer. Okay? And let them go through the first time. When they come through the second time and nobody has answered for the state that you're in and you want to answer as present, go ahead. Don't be shy. Okay? So, hope to see you folks there. We really need to get people together in all of these states. We got to get it done, folks. Running out of time. All right? All right. God bless everybody. Have a wonderful night. And see those of you in Wednesday night workshop through Patreon, which is, I forgot to talk about that on the website there, but that was the P there in the middle is for Patreon, plus that other link in the middle of it. For those that want to get into Wednesday night workshop, or you can support through there. I've got it set up as tier 1 and tier 2 to help support what I do right here on Monday nights, and then if you want to help support what I'm doing on Friday nights as well. So, and of course, on Thursday nights as well. I'm on those calls over there educating people as well. So, if you want to do a monthly donation over there through Patreon, the digital way, that's the only way I've got set up right now is through Patreon. Wednesday night workshop is tier 3. And for those of you that want to ask me questions about your personal case, that's one-on-one. That's over there in tier 4. Okay? So that's the way I'm doing this now, is I'm trying to, I'm out here running pretty ragged as it is. So if you want my time, that's going to be in tier 4. That's just the way it is. All right, folks? Have a wonderful night. God bless y'all, and we'll see you Wednesday night for those in Wednesday night workshop, and Thursday night, and then Friday night again. Okay? Good night, everybody.